against David Kingsley, indictment 25035. Back on October 20th, the defendant was convicted after jury trial of both counts 1 and 2 submitted to the jury. That is murder second degree as well as manslaughter first degree. We were adjourned to today's date for sentencing. The people move sentence.
We so move, Your Honor.
Would you like to be heard?
Briefly, Your Honor, before I speak, there are two members of Mr. Brooks' family who have been given leave to make a victim impact statement. At this time, I would first welcome Robert Brooks Jr. to the podium to make his statement.
Kingsley's the only former guard convicted of murder. His trial co-defendants were acquitted by the same jury, but others.
Thank you. Last December, I watched you beat my father to death on camera. You showed my dad no mercy at all. You treated my dad like he was an object and not a human. Watching your actions on camera felt like I was stuck in a horror movie and you guys were the monsters. I felt broken and there was nothing I could do. I will never get my dad back, but I do pray that your loved ones never have to endure the kind of pain I experienced. All of this could have been avoided if you and your fellow officers just did your job. My dad will still be alive. One thing I learned over the past year in this case, it matters to a lot of people, not just my family, but incarcerated people and their families all across the state. So many people are living with pain and fear about what this case has exposed. What happened in this courtroom matters. So I pray that the courtroom imposes a sentence severe enough to tell correctional officers that they cannot treat incarcerated people like animals. And I pray that this court imposes a sentence severe enough to tell incarcerated people that their lives matter. Thank you.
Today, I hope justice is served.
Mr. Hudson, anything further from the people?
Yes, Your Honor. As always, there really isn't much more that we can add when it comes to the loss that the Brooks family suffered. That's their province. That's what they understand. What we are here to talk about, what I'm here to talk about now, is the taking, the way in which they suffered that loss. Now, the facts in this case are clear, and they always have been. From the very beginning, this case has always been about the video. It's been about what that video showed. And it showed Mr. Kingsley from the very beginning, one of the first images we all saw when the media released those videos of Mr. Kingsley carrying Mr. Brooks' feet as he was face down, arms up behind him, blood already on his face as he got dragged into that infirmary and as he got thrown on that gurney where he would spend most of the last conscious moments of his life. But that was not Mr. Kingsley's only involvement. We've been adamant from the beginning of this case, this is not a one-injury homicide. This is not one thing that killed Robert Brooks. It's a constellation. But among that constellation, what happened to Mr. Brooks' neck burns brightest. And we heard at that trial extensively from Dr. Merkelova damage to the cartilage of Mr. Brooks' thyroid area, a broken hyoid bone, hemorrhaging all through his neck from even pressure. From even pressure that we watched Mr. Kingsley put on Mr. Brooks' neck. As in his entire 300-pound frame, he lifted a 140-pound restrained man off a table by his throat. For no reason. None. That's where that damage came from. But even then, when Mr. Brooks hit the table again, after Mr. Kingsley lifted him up, after he wrenched him by his neck, Mr. Brooks was still alive. He was still somewhat with it. Until Mr. Kingsley and Mr. Anzalone held Mr. Brooks against the wall for 4 minutes while he went limp, while he was doing nothing, while clearly the life was leaving him. And still Mr. Kingsley held him. Now, Your Honor, we don't always ask for the maximum as a matter of course in trial cases. We don't. It's not our office's policy. It's not Mr. Fitzpatrick's, Mr. Woodfork's. It's not mine. We ask for the appropriate, just sentence. And in this case, there were already other major players here who have been promised 22 years in prison. The major difference between Mr. Kingsley and them is not that Mr. Kingsley took his chances on trial. That was his right. The difference is that Mr. Kingsley made Mr. Brooks's family sit in a courtroom surrounded by people they didn't know and watch somebody they love die. And watched his face as blood was pouring down it, as the air was failing to reach his brain. And they were left dealing with that because of him. Because he alone, of every major player who inflicted horrible injuries on Mr. Brooks as he was helpless and he was in their care, he alone insisted on not taking responsibility for what he did. And it's for that, Your Honor, for that horror that was inflicted on Mr. Brooks's family over and above Mr. Brooks's death, that we are asking this court to impose the maximum sentence allowed by law of 25 years to life on murder in the second degree and 25 years in manslaughter in the first degree. Thank you.
Thank you, Mr. Hudson. Mr. Niebusch, would you like to be heard?
Yes, Your Honor. First, I'd like to, and I've been unable for the past year to send my personal condolences to Brooks family, and I do send my regards and sympathies to them. I think during this trial and my representation of Mr. Kingsley for the past year, I've gotten to know him and his family on a personal level. I don't need to go through the personal characteristics now, as Your Honor has read through the approximately 30 character letters that I provided to the court. They show a man of compassion, of caring, a correctional officer that spent years behind the bars of the correctional facility protecting and saving lives and lives of the incarcerated individuals there. The incident that took place that day, and throughout, well, before this trial started and during the trial and after, I've constantly heard that this was some sort of welcoming committee. That many of the correctional officers there were waiting in anticipation for Mr. Brooks to arrive and cause injury and pain to correct maybe his behavior. When this incident occurred, Mr. Kingsley was in a completely different building. He didn't know Mr. Brooks was coming in. He didn't know Mr. Brooks. He didn't know of any possible behavior issues with Mr. Brooks. This incident was ignited and sparked by a few correctional officers upon Mr. Brooks' arrival. Mr. Kingsley responded. And I think that's important because Mr. Kingsley was not indifferent to Mr. Brooks' life. And if he were part of that welcoming committee or the people that ignited this, then that may show that depraved or indifference to Mr. Brooks' life. And I think what shows that the most is after this incident, and the video wasn't showed during the trial, but when Mr. Kingsley learned that Mr. Brooks was not responsive because of medical reasons, he was the first to perform CPR. And the CPR that was performed was an effort to save his life, not to inflict injury. And that is the person that I got to know this past year. The person that cares and the person that tries to help and the person that tries to save lives. Unfortunately, this incident was sparked and ignited by a few other officers and responding officers that knew nothing of Mr. Brooks were caught up in that. And I think that should be taken into consideration in sentencing Mr. Kingsley. And I hope Your Honor has taken into consideration all the character letters that I provided and those two specific facts that were drawn up during the trial. And we ask that you sentence Mr. Kingsley to
English. Mr. Kingsley, is there anything that you would like to say prior to being sentenced?
Yes, sir. Much like Mr. Niebush here, I'd like to express my sincerest condolences to the Brooks family for the tragic loss they have suffered. I know nothing I say or do can ever change that outcome. I understand that. All of the events that happened over the last 3 days of Mr. Brooks' life should never have happened. Every single incident was senseless. Nonetheless, I would like to offer my heartfelt apology to the Brooks family. I am so sad to think that any action of mine that is untimely death, words cannot express how truly saddened and heartbroken I am that I was involved in such a tragic event that took someone's loved one from them. I, like many others, including the Brooks family, will have to live with that for the rest of my life.
Mr. Kingsley, be advised that you have a right to appeal this judgment of conviction. To do so, you must file a written notice of appeal. The clerk of this court, within 30 days of today's date, you may file this yourself, or you may direct that your attorney do so on your behalf. It is now the sentencing judgment of this court that the defendant be sentenced as follows. As to the conviction for murder in the second degree, the defendant is sentenced to an indeterminate sentence of imprisonment, having as its minimum 25 years in state prison, as its maximum life in state prison. As to the conviction for manslaughter, first degree, the defendant is sentenced to a determinate sentence of 25 years in state prison, along with 5 years of post-release supervision. Those sentences just imposed are ordered to run concurrent with one another. In addition, there is imposed a mandatory state surcharge, crime victim, and DNA fees totaling $375. The defendant is committed for the term of his sentence.
Your Honor, Scott Eisman for Mr. Fisher, who's standing behind me here. Good morning.
This is the matter of the people against Michael Fisher under indictment 25035. Again, the press is seeking coverage of today's proceedings. Does either side have any objections? Fitzpatrick?
No, Your Honor.
Eisman?
We object to video recording, Your Honor.
All right, the court will permit the same. This matter is on for a final pretrial conference with the defense jury trial scheduled to begin this upcoming January 12th. Now, we had addressed a number of issues at a previous appearance. I expect I'll get an updated witness list from the prosecution, but at the last appearance, Mr. Eisman, you indicated that you did not anticipate the defense having any witnesses. Do I have that correct?
As of now, that's the case, Your Honor.
You had also indicated you do want me to give the no unfavorable inference charge about the possibility of your client not testifying.
Yes, Your Honor.
All right, I'll also note for the record I did receive a signed Marcy waiver at the last appearance, and I'll continue to utilize that unless and until I'm told different by the defense. I'll remind the attorneys that the court does prefer exhibits marked in advance to the extent possible, and during jury selection, each side will be limited to 20 minutes per respective panel. If I'm remembering correctly, the prosecution had neither Sandoval nor Molyneux proffers. Is that correct, Mr. Fitzpatrick?
It is, Your Honor.
In that case, I have outstanding a number of motions that have now been made by both sides. Did either side wish to be heard concerning the various motions now pending, or do you wish to rely on your papers? Mr. Eisman?
Your Honor, there's one clarification I'd like to make with my most recent motion, which was a renewal of some general issues. In paragraph 47 of my most recent affirmation, which had to do with the motion to strike the portion of the amended bill of particulars, there was a reference to Docs Directive 4944 and the requirements of whether it addressed medical obligations on the part of DOCS officials. That, and the people took issue with that and pointed out that the directive does provide certain circumstances where medical attention should be required as part of the employment directive. The intent of that paragraph should be read with the preceding paragraph. The intent was to argue, consistent with my prior arguments, that there is a statutory obligation to provide medical care, and that was the thrust of the argument. And I asked that the court consider that paragraph in that respect, and not for any general statement that there is no larger employment directive under 4944 to provide medical care. Beyond that, Your Honor, I'm happy to answer any questions that the court may have, but otherwise rest of my papers.
All right. Mr. Fitzpatrick, anything that you wanted to add in addition to the responsive papers that were filed with respect to the defendant's motions?
No, Your Honor, we'll rely on our papers.
And then with respect to the motion to eliminate as filed by the prosecution, you'll rely on the papers for that as well?
That's correct.
You want to be heard in opposition to that?
No, Your Honor, I filed the responses, so of course,
That's what I received. All right, then. As to the outstanding defense pretrial motions, the defendant's motion to dismiss count 5 is denied. The defendant's motion to strike the People's Amended Bill of Particulars reference to failure to provide medical assistance, that is also denied.
We may meet again Monday. Did you?
Should I hear from counsel that that's necessary, I will calendar the matter for Monday.
Right.
Did you have anything else, Mr. Eisman?
no, Your Honor, thank you.
Very good. And I'll see you all on January 12th unless I hear otherwise. Thank you.
Judge, I apologize, Judge. I'm going to hand Mr. Eisman. We chatted yesterday by email. I'm giving him a general order of proof and witness list, exhibit list. As in the last trial, well before January 12th, he'll have our order of proof as well as a copy of our exhibit list.
I appreciate that. That certainly helps everything move along more smoothly. You can forward the same on to me. I appreciate it as well.
You got it, Judge.
John
Thank you.
has a copy for me. That'd be great. You can give that to the court officer. All right. Thank you all.
Thank you, Your Honor.